On June 29th, the U.S. Supreme Court issued a landmark ruling concerning race, and race is a factor in admissions to colleges and universities. The decision changes decades of understanding within the higher education community about the role in which race may play in admissions. The decision has created quite a buzz and quite a stir, of course, as one would expect, but not only within the realm of admissions and higher education, but employment more generally. Employers are turning to their own hiring practices and wondering what the impact of its recent Supreme Court decision is on their, for example, diversity, equity, and inclusion initiatives. The short answer is that there is no direct application. The Supreme Court decision in Students for Fair Admissions versus Harvard and the twin case involving the University of North Carolina are decisions that are very particular to student admissions and to that process. But the larger point, the larger optic of the cases, which is that when one considers race and makes a decision based on race, that decision may be unlawful. That is something that is applicable in the employment arena, and frankly has been prior to the time that the recent Supreme Court decision came out. This is a good time to think carefully about your hiring practices. It is an excellent time to sit down and talk with legal counsel about the boundary between permissible and lawful ways to pursue diversity, equity, and inclusion within your workplace, and frankly, the legal line over which those initiatives cannot cross, or they do become unlawful considerations of race.